Welcome to the 5th video in the Appropriate Dispute Resolution video series. In these videos, you will be introduced to a dispute between two parties, and we will be able to track the dispute through the alternative dispute resolution processes. Jules and Lauren, having only been able to resolve some of their issues in mediation, have now progressed the dispute to an arbitration conducted by a single arbitrator. The parties have signed an arbitration agreement setting out the rules by which an arbitration will be conducted and appointing the arbitrator.
Welcome everyone. I'm glad we're all here so that we can begin this arbitration on time. I have in front of me an arbitration agreement that I believe has been executed by both sides that sets out my powers and the procedure that will be followed today. Has everyone signed that agreement? Yes? Thank you. For the sake of clarification and simplicity, I'll simply point out that the rules provide that I can inform myself in any way that I think is appropriate of evidence or information that I need in order to make my decision. Unless it becomes necessary and in the interests of saving time and money, I will dispense with calling of witnesses and I may question witnesses directly. There will therefore be no sworn evidence given today. Does this meet with the party's satisfaction? Thank you. Before I take appearances, I should point out that this arbitration is being conducted in accordance with the Commercial Arbitration Act, and as such, it will be recorded. At the conclusion of the process, I will render a written award which will form a judgment for the parties. Now, I might take appearances.
Nathan Jones on behalf of the applicant.
Thank you.
Jacqueline Chase, I appear for the respondent.
I've been provided with the notice of dispute and a response from each of the parties, which I think has been quite thorough, and I appreciate that. That notice sets out what I believe are all of the issues that are in contention between any of the parties, and looking at it, it seems to me that the principal issues are now quite clear for everyone, and that everyone understands what this dispute is actually about. Is that satisfactory to all the parties? Yes. Right, thank you. So I might call then upon Mr. Jones for the applicant to make an opening statement.
Yes, thank you, Mr. Arbitrator. This is a small dispute brought pursuant to the Commercial Arbitration Act. It concerns a paving dispute in which the applicant, Ms. Lauren Smith, alleges that the respondent, Jules Gold, trading as Perfect Paving, performed substandard service leading to the quick collapse and deterioration of paving works done at the applicant's home. Now, the parties have succeeded in narrowing the issues, so the only matter for you to determine here today are those set out in the Notice of Dispute. They are A, who should pay for the cost of labour for the repair works done by the respondent, the parties having already agreed that the applicant would pay for the materials, and B, whether the respondent should refund any part of the costs he originally charged for the initial works, the total cost being $5,000.
Right, and was that with GST or excluding GST?
Including GST.
Thank you.
Mr. Arbitrator. The questions of law are fairly straightforward, being a determination of negligence, liability under the Australian consumer law, and breach of contract.
Stop you there. It seems to me that one of the basic questions should be fitness for purpose. Is that part of your pleading?
Yes, it is indeed, Mr. Arbitrator.
Thank you.
Ultimately, we will show that the responsibility for the repairs lies with the respondent, having conducted substandard work. The respondent, therefore, should also refund $3,500 of the costs of the initial works done.
Thank you. I might just address Ms. Chase. Ms. Chase, does the respondent agree to the factual elements of that summary, and are these the actual issues in dispute?
Yes, Mr. Arbitrator, that is a fair summary. We deny any negligence and will show that the applicant caused the damage by failing to care for the paving properly.
Thank you. Are there any documents that the applicant wants me to consider?
Yes, Mr. Arbitrator. I might begin by handing up contracts, flyers, and also the respondent's business cards.
Right. I take it that these documents are common to the parties?
They are, with the exception of one document, which, with Mr. Arbitrator's permission, I'd like to tender to my learned friend.
Thank you very much. I'll receive those documents now. Thank you. And if you'd like to tender a copy that you have sitting next to you to the respondent, that would be very helpful. Thank you. I believe it's now your opportunity to present your case, Ms. Chase.
Yes, Mr. Arbitrator. Now that we are presenting our case, there is one essential factor for you to consider. It is openly agreed between the parties that, if laid properly and properly cared for, paving shouldn't fall apart in days. Our client contends that the work was properly done and that the applicant did not care for the paving properly. This resulted in the damage seen. I'll now tender an expert report to you. It has previously been provided to the opposing side and an opportunity was given to ask the expert questions.
All parties continue to give evidence until the arbitrator is ready to conclude proceedings.
I've considered everything I've heard here today, and there's been quite a bit of material and evidence that's been tendered to me, which I will take some time to consider, even though the materials and the views expressed seem to be relatively straightforward. It is therefore my intention to directly render a final award and not to render an interim award along the way. In accordance with the Commercial Arbitration Act, there will therefore be no provision for either side to comment on the award before it is rendered. The parties will therefore be in possession of my final award within, I estimate, 10 days. Thank you very much.